Welcome to all. If you have not yet met me, my name is John Niles, and I am CEO and managing shareholder of the law firm Carpenter Chartered. Presenting with me today is Will Obringer. Will is a managing associate attorney with us, and also with us is Tammy Severson, our colleague and executive assistant, who's been absolutely instrumental in putting together today's presentation. What we're here to discuss today is the recently certified Freund class action. And we understand that class actions are still very new in veterans law. We anticipate that representatives such as yourselves and many veterans and survivors may have questions, whether they're coming to you for potential representation or our current clients about this class action, what comes next, what's the status. And so we've identified four areas of likely questions that we wanted to be sure to address with you today. We would welcome absolutely any and all questions that you have. We are, again, recording today's webinar for other accredited representatives who are unable to join us today. And so please, if you do have any questions at any point, you can put them in the chat. I see we're already getting some questions, which are fantastic. The first question is, will we be getting this material, the slide deck? Yes, we'll be following up this presentation with a link to the recording and with the slides themselves. And please, please, please freely distribute the slides. We understand that there may be folks joining us from law firms that have, or other organizations that have just a couple of folks joining us, and there are more people who might be interested.
Yes.
Oral argument rules will apply, where if I hear somebody come off of mute and it seems like they're starting to ask a question, I will stop mid-syllable, mid-word, mid-sentence, does not matter. And so be intentional with mute, muting, unmuting things happen, but please do not hesitate to ask questions. If you have met me before, you will know that speaking from a prepared deck is one of my least favorite things to do. I will welcome questions. I'd much rather speak with you than talk at you about these questions that are going to be affecting your firms beginning very, very soon. The four areas of questions that we identified as wanting to cover today are, first of all, understanding the class the court approved in the Freund class action. Or to say that differently, what group of individuals did the court define as having their claims in this action either rise together or fall together? And so I want to make sure you have a firm grasp of what that class encompasses and what it does not. Second, then, after understanding what the class definition in Freund is, how are you going to go about identifying whether particular clients are or are not within that class definition? And so what we intend to do is present a very nuts and bolts based approach of, from the claims file, how can you make this determination, or as far along as you can get with a reasonable time and energy expenditure to at least raise with VA the prospect of, hey, it sure looks like this appeal file is one that belongs to the Freund class. Can you take a look at this? The third subject we're going to address today is, this is a class action where the parties have agreed to a proposed settlement agreement, and they have filed that proposed settlement agreement. It is before the Veterans Court now for review in terms of, is that agreement fair, adequate, and reasonable? And so what we're going to do is will step us through some of the proposed settlement agreement's key terms. Will then address the key dates that are coming up in litigation to the extent we know them. You'll see in that piece of the presentation, there are some dates that we have to bracket, bold, italicize, but question mark by, because they're not yet established, but we want to at least give you a heads up now of roughly when to expect for next steps to occur. As those dates then become more calcified, we will follow up with you to let you know, hey, this is when the precise deadline is. We said to expect it around here. We now have the exact date. This is the exact date. And at the end of the presentation, I'll go back through, summarize the key takeaway points we want you to leave today, bearing in mind, and of course, addressing questions all the way through. So first topic then, understanding the Freund class. And here it'll be helpful to take a step back and have me address what the Freund class litigation addresses. And what the Freund class litigation addresses is a systemic problem that affects a very particular point in the claims process. And in particular, as you'll be aware, VA is administering in parallel two separate appeal systems, the legacy system and the AMA system. The particular problem that Freund seeks to correct, it's within the legacy system and the legacy system only, where VA, due to a systemic problem, has been erroneously closing timely, perfected substantive appeals. And so in the legacy system, VA would issue notice of a decision. The claimant then would have 1 year to file a notice of disagreement, a legacy notice of disagreement, notifying VA they disagree with the decision. VA then would prepare, typically, there are exceptions to this, but this is the branch that is pertinent to Freund. VA would prepare a statement of the case. And after that statement of the case was issued, the claimant would have a certain period of time to file a substantive appeal. And that time period was the later between 60 days following the statement of the case, or if the statement of the case was issued close in time, relatively close in time to that initial notice of decision, such that there was still additional time to go up to 1 year following the notice of decision for that, the notice of the original decision, the veteran could then file the substantive appeal out to as far out as 1 year following the notice of the initial decision. So that substantive appeal, the VA the claimant had to file typically within 60 days of the statement of the case, but in exceptional cases, it could be after that, so long as it was still within 1 year of the notice of the original decision. And what went wrong here is against that 60-day deadline, VA for years had delays and at times very lengthy delays in processing into its electronic database systems the substantive appeal documents that it received. Meanwhile, as far back as VA had its primary, what became its primary electronic database for controlling these appeals, these legacy system appeals, those are the Veterans Appeals Control and Locator System, or VACLs. VA within VACLs was running a periodic, typically monthly sweeping function, where VA had essentially a software program that went through all of the appeals in vehicles that were still being shown as active. And if vehicles did not show a timely substantive appeal as having been filed, meaning that not only had the substantive appeal actually been filed, but the record of that substantive appeal having been filed had been processed and put correctly into vehicles. If the sweeping function didn't see a timely date, then that sweeping function would automatically close the appeal. Or to say that differently, it would deactivate the appeal. Or to say it a third way, it would warehouse the appeal. And when that monthly sweeping function closed or deactivated or warehoused the appeal file, the legal status was this is a timely perfected substantive appeal. It needs more processing. The claim stream remains open. But as a practical matter, VA is not doing anything with it. It's stuck at the agency of original jurisdiction. And also when this happens, VA is not providing notice to the veteran, not providing notice to their representative. And all of this is happening during a time when board decisions were taking a long, long time to get out. And so from the appellant's point of view, it looked to them like, hey, I know that I filed the substantive appeal and it's timely and VA has it. And it looked to them like they were just waiting in line. And so you have this appeal file that is closed, that is sitting there, unless something were to happen. And in many cases, it did not. Nothing happened. And so this is what we brought the Freund litigation to help correct, not only for two clients that were suffering this problem, but we believe based on an OIG report that it was affecting thousands. And so then what you'll see with the class litigation is that it went through ups and downs and finally got through to the Veterans Court certifying the class. and it defined the class narrowly tailoring the class definition to the problem then that we were trying to remedy in this class litigation. And so we have the definition. It's been on the screen for a while. I'll read it anyway and just go through it over the next slides, particular pieces of it that I believe are going to be relevant to you as clients start calling in and prospective clients start calling into you to have this information on hand to respond.
Hey, John.
Yes.
Just so you know, we have our first question from the chat. So I wanted to read that out to everyone.
Please.
The question is, would this apply to if the veteran filed an NOD to the board and the board subsequently said it wasn't timely, despite the VA saying it was perfected and timely and closed the appeal?
It would not. It would not. So a couple things here. In the legacy system, the notice of we were still filing what was called the substantive appeal, and typically, but not always, that was on the VA Form 9. So VA did prescribe a form for this. There were years and years for which you did not have to use the prescribed form to file a substantive appeal. And you file that substantive appeal with the regional office rather than the board. And so back then, the regional office would have been responsible for screening the substantive appeal for timeliness. And the regional office then would issue a decision as to timeliness if it believed that the substantive appeal was untimely. And if that happened, that means that it's something different than what happened with these Freund, the substantive appeals that are within the Freund class. Because with Freund, it just never got that far. You had even before you got to the point where the agency of original jurisdiction would have somebody put human eyes on the file and say, is this substantive appeal timely? The appeal file already would have been closed through this automated sweeping function. And so if there was a decision as to timeliness from the AOJ, then that would not be a file. It's a great question. It would not be an appeal file that would belong to the Freund class. And then separately, nowadays in the AMA, we are filing appeals to the board directly with the board itself. And so if you have a letter from the board saying that you have an appeal that is untimely, you know right there that it's going to be an AMA appeal, unless there's a separate problem going on. But either way, it is somebody putting human eyes on the file. And so you know that if it had gone into vehicles, it would have passed through this gap, this particular gap that Freund addresses. And so the certified class, as the Veterans Court defined it, and this is something of we had proposed one class definition at the beginning of the litigation. And then we negotiated with the secretary a second, actually broader class definition. And then the court came back with its own class definition, which it has the power and authority and discretion to do. And the court said, here is the class that we are approving. We are saying that anybody belongs to this class. They are a claimant with an appeal file in the vehicle system that has been closed anytime during the period between December 12th, 1990 and February 2025 due to the lack of a timely filed substantive appeal in which appeal remains closed. And that last bit then, which appeal remains closed, means, well, if it's been reactivated already, you have your relief and move on with life. These other terms in here do warrant a little bit closer examination, including claimant. And I want to stress that claimant is not just the original claimant, but also if the original claimant has passed away, any substitute claimant would be enough. And that's going to be important because this class period, it goes back to December 12th, 1990, as far back as VA was using the vehicles database. We know that claimants unfortunately pass away. Many pass away with just the ordinary delay of the VA system. And so you will will is probably too strong. You may, there's a very real possibility that you will encounter appeal files where the original claimant has passed away. But as long as there is at least a potentially eligible substitute claimant, then that potentially eligible substitute claimant or the actual substitute claimant would still qualify for class membership here. In the class definition, there's also this phrase, due to the lack of a timely filed substantive appeal. That ends up also being broad language. I mentioned that VA had a prescribed form, the VA Form 9, for filing a substantive appeal. We looked at whether to seek to define the class just restricted to substantive appeals filed on a VA Form 9. It would have made the class membership that much easier to ascertain. We went with the broader substantive appeal language, and the court accepted that. So, due to the lack of a timely filed substantive appeal, that means any substantive appeal, no matter whether it was on the VA prescribed form, the VA Form 9, or its predecessors. It could be on a VA Form 21-4138, the statement in support of claim. Could have been in a letter, particularly if you're talking about March 24th, before March 24th, 2015. Could have been in the back of a napkin, labeled as third-party correspondence. And so when you are looking for, to answer these questions from clients, am I part of the Freund class? Do not restrict yourselves to just reviewing only VA Forms 9. Any communication that would qualify as a substantive appeal that would be timely then if where the appeal file has been closed, that would be enough. Also broad here. Oh, somebody come off of mute.
John, that wouldn't apply after March 2015, though, correct? Sorry.
No, yeah, it would. And then the question would be if the document was filed after March 24th, 2015, is it actually a substantive or is it a valid substantive appeal? And so what you'll be looking for, and we're going to discuss this later, is at this point, the way that the class is set up, or to get relief within the class litigation set up, is that you don't at this point need to go so far as to say this absolutely is an appeal file where there was a substantive appeal, filed during this relevant time with, and meeting all these criteria. What you're going to do is do your best to identify, say, hey, this sure looks like one to me, and I cannot rule out that VA erroneously closed it and then failed to reopen it. And so if you are raising to VA the prospect of, hey, this is a Freund class appeal, then that's going to be enough to make VA do an audit of that appeal file. And you'll hear from them, right? And you're going to hear from them in terms of, well, this would be a substantive appeal, except for it was the wrong form filed after March 24th, 2015. So they'll give you that wrong form rejection letter. And then at that point, you can take issue with that. And you can challenge that and say, well, but I think this is a Hall versus McDonough situation where this is a claims processing rule where you are restricting the form of this filing to the prescribed form. And so it would be an uphill battle, but it would be a battle you can fight. And you would at least have that forward momentum to get toward a decision, whereas right now, the appeal file is just warehouse doing nothing.
Okay, great. Thank you.
Thank you. The precise reason why these appeal files were closed does not matter. So long as they were closed on the basis of having no timely filed substantive appeal. And what I mean by that is I've talked about this automated sweeping function that VA ran monthly, and that is the primary reason why these appeal files got closed. But there were also other errors that occurred, right, where VA was processing in time to meet that monthly sweeping function, the substantive appeal, and somebody mistyped the date. Because they mistyped the date, the substantive appeal looked late. And so when that sweeping function came through, it said, oh, FACL says it's late, it must be late, closes the appeal file. That would be in 2, right? If somebody's, and I mentioned that because one of the major requirements you have to meet for class certification is a requirement of commonality, where the class members have to raise a common question of law or fact that is capable of a common answer, common legal resolution. And so where the Veterans Court stopped in terms of digging down and down and down to try to cleave differences between the class members is as long as a substantive appeal is being closed on the basis of no timely filed substantive appeal, that's going to be enough. We're not looking at, okay, was it the sweeping function itself versus somebody mistyping versus somebody spilling coffee in their lap, or not coming to work that day, or what, however particular you want to drill down for the underlying reason. It's enough that the appeal file was closed because the substantive, or on the basis that in VA's determination, or at least the automated, well, that it was closed on the basis of not having a substantive appeal file that was timely. The appeal file being closed in the period between December 12th, 1990 and February 6th, 2025. Well, why these endpoints? December 12th, 1990, it goes back as far as VA was using vehicles. VA could not rule out that it was using this automated sweeping function to close appeals, even from the inception of vehicles. By February 6, 2025, by that point, VA was aware of this problem. The Freund litigation had already been pending for several years at that point, and VA had already gone through and attempted to moot out the putative class action at that point. And so meanwhile, right, we have the AMA, and there are fewer and fewer and fewer statements of the case being issued under the legacy system. So by February 6, 2025, this particular kind of error was no longer occurring. And then to reiterate, substantive appeal, again, Freund addresses legacy system appeals only, and that substantive appeal is broad, that language. It's not VA Form 9 or similar. It is any form of substantive appeal. VA has reactivated thousands of timely filed substantive appeals that had initially erroneously closed. The relief that this class action seeks is ultimately reactivation of those kinds of appeals. And so once again, if the appeal file already has been reactivated, you get to tell your client, well, you've already gotten this relief. You don't need to worry about what happens next in Freund. You're already, you're beyond that step. So to put it all together, all these elements together into the Freund class definition, it's all original and substitute claimants, including potential substitute claimants with an appeal file in vehicles that has been closed anytime during the period between December 12th, 1990 and February 6, 2025, due to the lack of a timely filed substantive appeal being identified in vehicles before a vehicle's monthly automated sweeping function ran through and closed the appeal. And again, if there was an intermediate processing error in inputting the data that then caused that appeal file to get caught up in a later sweeping function, it's still good to go. And which appeal file remains closed today? Question here, are resulting board decisions issued under legacy or AMA? These are still legacy appeals. They are the same legacy appeal that if you had the initial decision came out in late 2004, and you had the notice of disagreement come in, and you had an amazingly quick, well, we'll say a 2006 statement of the case, and then also 2006 substantive appeal. That's all legacy. And today, what happens next is when this appeal gets reactivated, one of three things is going to happen. Either VA at the regional office level is going to grant the appeal, or it's going to issue a supplemental statement of the case in the legacy system, or it will certify that appeal up to the board still in the legacy system. And so what I expect will happen, because just of the sheer amount of time that has passed on the vast majority of the appeals, is that if there's no full grant being offered right now, it's going to be a supplemental statement of the case. That supplemental statement of the case will come with it a 60-day period to opt into the AMA. And so you will have an opportunity, very, very likely, to opt these appeals into the AMA. But in terms of what comes next, where they are now, and the very next action from VA on them, expect them to still be in legacy. I'll pause for a second. First of all, to get a drink of water, and then to address, I see one more question. If there are any others, please type them down.
I'll read it, John, so you get your water.
Thank you.
So are there instances when vehicles closed potential substantive appeals automatically when there was still potentially time to file a substantive appeal due to triple evidence, for example?
I won't rule that out. We haven't run, I did not see affirmative evidence of that occurring. But from my understanding of how VA ran its monthly sweeping function is that typically all it would do is wait for it would calculate the deadline for the substantive appeal based on the later between 60 days beyond the statement of the case or 1 year beyond the notice of initial decision. And then 5 days after that, because VA was assuming it would get paper mail or the equivalent, and you have the 5 day additional period, it would wait and that minimum I typically have been saying 65 days because so many of these are tied to the 60 days after the statement of the case. But after that period is after it would run the first sweeping function that would affect that appeal file. And so if there is an extraneous event coming in, like new evidence coming in, vehicles itself would have been blind to that. And so, yes, I believe that there are going to be instances then, logically speaking, even though or conceptually speaking, though I haven't seen direct evidence of it, where vehicles would have erroneously closed that appeal even before the appeal period ended.
All right, our next question, John, is how long do you think the average time will become for a Board of Veterans Appeals judge to even look at an AMA NOD once thousands of these flood the board as legacy appeals?
Yeah, this is a real problem. It's a real problem not just for the Freund class members, but for everybody with the Board of Veterans Appeals appeal that is pending, right? I do not know how the board is going to prioritize between the legacy system and the AMA system in terms of and I'm changing the frame of reference here, right? From the question to just AMA, assuming an opt-in. So let's first of all assume no opt-in, because these are going to start as legacy appeals. Let's say there's no opt-in. I don't know how the board is going to, going forward, prioritize getting through what will be a stack of these appeals. And it could be quite a substantial stack, and we'll get into the numbers a bit later here, versus the AMA appeals already in front of it. And then if you do opt in, right, and you're filing a 10182, that 10182 is going to bear and be considered in terms of the first filed, first served date at the board to bear the date of the 10182 as opposed to the long pending file going back years as it was in legacy. And so it could be a while. Now the board will be applying its regular rules of expediting appeals or advancing appeals on the docket that it does for other appeals. But you're going to be looking at a docket date of sometime 2026, 2027. And so do bear that in mind when you're looking at the election of, do I opt this in? Do I believe that the VA really wants to close out all legacy appeals? And where then I would expect the board to prioritize these. And we know that the filing date goes back years and years and years. And so expect very quickly versus if I opt this in, yeah, I get this ability to start over with supplemental claims, but it could be a longer board wait if you do at that point choose not only to opt it in, but to go up to the board. I do imagine that there'll be some cases that would be well handled at HLR or supplemental claim review, but it's a great question.
And John, I want to,
yeah.
I was going to say, kind of we've talked about this, and I think this is kind of follows in with that, is that the VA is not creating additional forms. They're not creating any additional, as part of the class settlement. There is no specific identifier that these cases are to be, put aside or expedited outside of the regular VA process. Is that correct?
Yeah, that's right. And so what you have here in VA's eyes is they have the VA's already had mechanisms for if you had raised with the Office of Administrative Review or its prior iterations, or if VA on its own had been reviewing an individual appeal file and said, oops, it's been erroneously closed, then on a one-off basis, it would reactivate that appeal and go for it, treating it on the basis of docket order, but treating it the same as any other substantive appeal that was filed whenever yours was filed. And that's going to remain true, even though now VA is doing this entire batch now, where even though the scope of the remedy is changing, the substantive nature of it is not. Did that respond to the question? And I'll assume yes and keep going here. Identifying your individual class members. So on February 7th, 2025, this was part of the negotiations toward a classified settlement. VA ran searches across vehicles and then cross-referencing the Veterans Benefits Management System, VBMS, where VA is holding not just these legacy appeal file tracking information, but instead has the actual claims file. And so what VA did is it ran searches in vehicles to see, okay, vehicles has information that we can rewind and see, yes, this is an appeal file that was closed on the basis of having no timely filed substantive appeal. And then VA narrowing down its search within VBMS to just those files to see, okay, among those, which during the period that if this were a substantive appeal, had a document in VBMS that might qualify as a substantive appeal. So stated differently, in vehicles, you have this you can tell which appeals were substantively closed or were closed on the basis of having no timely substantive appeal. And then searching in VBMS among those to see, well, which of these have documents that look like substantive appeals that were received by VA within the pertinent time period. And when VA ran those searches, it found 28,258 appeal files for which VBMS contains, from the period to be timely, a document that VBMS identifies as a substantive appeal. And there were a few different ways that VBMS did this, either identifying as a VA Form 9 in terms of the document category, or a very closely related field there pointing to the VA Form 9. When VA ran those searches, it found an additional 64,599 appeal files for which VBMS contains for that pertinent time period. For if this was a substantive appeal, then it would be timely as a substantive appeal. One or more documents that VBMS identifies as a VA Form 21-4138, the statement in support of claim that we know was the primary vehicle that if veterans or survivors were not using VA's Form 9, they were using a lot of the time the 4138 to put in the informal legacy notice of disagreement, legacy substantive appeals. We're going to focus on that latter group, 64,599, right? So they belong to the Freund class if those 4138s are in fact substantive appeals. Not all are. They're going to be false positives. Some of the 4138s will end up being just entirely blank, where VA is providing notice of decision, and in connection with that, here's a blank 4138 if you want to use this in connection with your next submission. Some of them will be 4138s that pertain to entirely different claims, but there absolutely will be statements in support of claim filed within, I'll say, the 60 days here following statement of the case, but also within 1 year of the initial notice of the decision, that will end up being substantive appeals that then let you reactivate this potentially long pending timely perfected appeal to the board. I do want to highlight too, the VA searching February 7th, 2025 also identified many additional kinds of document categories in VBMS that, of course, right, within the 60 days following the statement of the case, there's other stuff coming into the claims file. There's third-party correspondence, there's correspondence, there's, other notice letters and other things that higher rate of false positives, but there may be things in there, especially we all know that there are many documents that are tagged in VBMS as third-party correspondence that turn out to be something different, something more substantive. And so in addition to the 25,258 VA forms, documents coded in VBMS as VA Forms 9 are very similar. And in addition to the 64,599 appeal files would have VBMS a 4138 from the pertinent time period, there are going to be potentially many additional appeal files that have timely perfected substantive appeals that are coded in VBMS as something different that VA then erroneously closed. So your focus, you're going to identify timely substantive appeals. And instead of trying to pass the bar of saying this is a substantive appeal that you erroneously closed and that remains closed today, what I would encourage you to do is at least try to, hey, this looks to me like a timely substantive appeal, and then attempt to rule out the appeal file having been closed for the lack of it. So rule out that this is a false positive, and then attempt to rule out the appeal file remaining closed. And I phrase it this way because you're going to have imperfect information. And so you're going to get as far as the information you have can take you. And if you can't rule out this appeal file as being a Freund class eligible appeal file, then write to VA and let them know, hey, I think I have a Freund class eligible appeal file here. Please take a look. Please see if there's something here to reactivate. Digging deeper then and talking about what you're looking for within the claims file, you're going to identify each statement of the case. This is going to take work. Client calls in and says, I think I have I think I'm a Freund class member. Can you help me decide whether I am? You're going to identify each statement of the case. And then for each statement of the case, you're going to identify when, if ever, VA received a substantive appeal. Again, not limited to the VA Form 9, not limited to the 4138, but what you can identify is this sure looks like a substantive appeal to me, filed within the correct time period. For each timely substantive appeal, what I recommend then doing is trying to rule out that it was in the Freund, that is eligible for Freund class relief. And what I mean by that is that if there is a VA Form 8 that links up to the same issues that are in the statement of the case, the VA Form 8 was the form that VA used when the agency of original jurisdiction was certifying to the board. Yeah, this is an appeal. We received the substantive appeal and it's good to go for your review. And we're going to then transfer jurisdiction to you so you can docket it and decide it. If there's a VA Form 8, it means that the appeal was not closed in vehicles on the basis of no timely substantive appeal, which means it is not a Freund class eligible appeal. Something else wrong that might be going on wrong with it. There's the first class action that the Veterans Court certified. It was in Godsey versus Wilkie, where VA had long delayed issuing these VA Forms 8. But if there is a VA Form 8 that matches up to their statement of the case in the claims file, you know that this is not, or that particular appeal stream does not make this appeal file a Freund appeal file. Similarly, looking beyond that, if the board docketed the appeal or even the board decided the appeal and the issues line up, really any of the issues line up with the issues that were in the statement of the case, you know that the appeal file wasn't closed erroneously, or at least doesn't remain closed today. Something happened beyond it. And so you can rule that out as far as being a Freund class appeal. What you're looking for is any timely substantive appeal where none of those three later procedural actions occurred. And so that's at a nuts and bolts level. Then when you're looking to VBMS, go look for the statements of the case. Go look at the pertinent time period beyond that. See what you can identify as a potential substantive appeal. And then when you find a substantive appeal that looks like, hey, this is timely, look at what happened after that. And if you don't see a VA Form 8, you don't see the board docketing, you don't see a board decision on those issues, then write to VA, say, I think I see something here. This looks like there was a timely perfected substantive appeal. I don't see anything else on it. Sure looks erroneously close to me. Will now address the key terms of the proposed class-wide settlement agreement that the parties have negotiated and put to the court for review in Freund. Oh, wait, and before that, I see some questions. One, could you please repeat what is considered timely under the legacy system? Yes. There are two different ways for a substantive appeal to be timely. So you always have 60 days following the issuance of a statement of the case to file a substantive appeal. So it's the statement of the case's date plus 60 days. And those 60 days, of course, if the deadline falls on a Saturday, a Sunday, or a legal holiday, you bump it to the next workday. So that's number one. Way number two is you also have 1 year from the date of the notice of the initial decision. So if there is a VA Form 21-526 or 526 EZ claiming sleep apnea, service-connected compensation for obstructive sleep apnea, VA sends out its notice of decision denying service connection for obstructive sleep apnea, say on February 2, 2005. If VA then issued If the veteran filed a notice of disagreement, VA issued a statement of the case really early on, then the veteran would still have the full 1 year period from that notice date of the initial decision, February 2 of the next year, to file that substantive appeal.
So James, who just sent a question in. Oh, so I'm sorry, I was going to answer that question, but did that answer the question about the timely? Okay, good. So James, thank you for asking that question. You just jumped into that's perfect lead in, which we always appreciate. Helps make us look a little bit better here that we know what we're talking about. So there will be notice going out, and then I'll get to that in the next slide. So when we look at the timeline of the case was the Freund family and the VA agreed in December to a settlement agreement that went to the court. In early March, the Veterans Court ordered the VA to publish notice to the world that there is this class settlement, identifying the potential class members. And they must do that within the next 10 days. So that is why one of the reasons why we decided to host this, because we believe veteran VSOs, representatives, agents, attorneys are going to be getting a lot of phone calls because they look in the VA website, they get it in their email, they get it from a local VSO or a friend that says, I got this, did you see this? Did you file a claim back in the day? And you may have this claim. So we believe, oh, John, you're, okay. So we believe that this is going to happen very quickly in the next 10 days. The VA is required to, under the class settlement, to send a notification, to send out the notification, and it will do that. But this is what it's also going to entail. So the proposed class settlement is this. So first, as John went over who the class is, the class settlement is this. It's going to be for that 28,258 cases that the VA has already identified in vacals that has a substantive appeal. They are going to audit it. They are required to audit those cases to determine whether or not those cases are to be reactivated. And it's going to identify, then it has to identify if the case is to be reactivated, and it'll provide notice to the claimant or to a substitute claimant, and to those potential substitute claimants. So this is not just to a potential surviving spouse that is known. It will also, the VA will also follow its own normal rules in identifying potential claimants. So it will look through its records of surviving kin. It will look through VHA records if there are survivors or maybe caregivers mentioned as well. But it will not go to the ends of the earth to identify potential claimants. It will follow its own rules. If there is a claim that has been audited, there is a 1 year period. And this is for the second group of people, the 64,000 approximately. If there is they're going to send notice out to that. So there is individualized notice going out to all individualized members. Oops. The individualized notice will go out to all members of the class, identifying them that there is a potential that you have a closed case that was erroneously closed, that you may be part of this group of the Freund class settlement. So there's going to be almost 100,000 notices going out across the country, identifying people that they have a case that may be potentially open. Now, the main difference is the group that is the 28,000 that we know has a substantive statement of the case, a substantive appeal in there. These individuals will get audited. The other group, this larger group, this 64,000 plus group, will get the individualized notice. But they will also then be told that you have the potential. If you think your case is closed erroneously, you contact the VA and we will audit those cases. So there is some timelines associated with that, and I'll get that in a minute too. But this is where you as the the representatives are going to come in as well, because we believe that this is going to raise lots of questions. Oh, I have a case here, I don't have a case here, and you're going to help them identify whether or not there is a substantive appeal in there. And this is where we also believe that those 4138s are going to really show up and say that somebody filed an appeal. And if they do have an appeal, it will be audited. And once there's an audit notice, they will then then the VA will inform them that there is an audit, and then the VA will take appropriate action once that audit is complete. Now, the other thing is the VA is also committed to saying, hey, if on record, if there is a representative, they're going to inform the representatives as well. So this is going to go out en masse to the claimants, potential claimants, and to the VA, to the representatives itself. So if there is an audit, so first there's the individualized notification. And then if there is an audit, the VA will do these. They will reactivate the appeal if it believes that there is a timely substantive filed appeal. And then it will give them notice. It will be, you have 60 days to provide evidence. Or they're going to tell them you're going to go to board, or it's going to issue a supplemental statement of the case, which will then allow the claimant to potentially opt in to the AMA system if that's what they want to do. And as we discussed earlier, that's where your job is going to come in, and to advise them on the best course of action to take for these groups of people. So again, and then once the case has been reactivated, so there's initial notice, then there's the notice of the audit, then there's reactivation notice. The VA is going to tell them what to do. And so there's going to be several notices going out to the individuals, and you're going to have to help them through this notice process and what they can do. Because once the case has been reactivated, there will be the opportunity to submit evidence, to submit buddy statements, to get medical records, to get updated information, including literature that may not have existed in the early 2000s that now is common, especially things like linking obstructive sleep apnea to post-traumatic stress disorder. So that kind of evidence will then be able to be added to the case at that time, depending on, again, the process. And then the VA is going to obviously give the claimant the opportunity to respond, but it's going to be up to you then to help them get that information to the VA so their claim can be settled. And then again, we talked about this. This is going to talk about what the claimants can do and what the VA's obligations are as well. All right, so some of the key dates coming up. So once that notification goes out, that won't happen this month. By the end of April, by mid-April, the VA is going to inform the world that there is this classification. That is the next key date. We assume it's going to be April 17th, the VA acting on the last possible date, but this could change depending on when the VA decides to publish its notification. 30 days after that, the deadline for objections comes in. So when the VA issues its notification, it's going to say, this is a class settlement. If there are members of the class who object to this settlement, to the notification requirements, to the audit requirements, those objections have 30 days to get sent to the Veterans Court. Once that is done, the court will gather all of those objections and hold a fairness hearing to determine whether or not those objections are merited and whether or not the class action settlement is valid. It should be amended, should be accepted as is, and that will then trigger the court to issue a statement of settlement fairness hearing and a statement after that to propose whether or not the settlement is fair, reasonable, and adequate. And that will be the mandate. So after that fairness hearing, the court will then issue a mandate. And that mandate is what triggers the time periods for the VA to begin accepting, auditing, and then reactivating cases. And then for that 28,000 group, for those other groups, that's when the notices will go out to them, the individualized notices, and the claimants will have a year to respond to request an audit on their file. So throughout this audit process, so if one of your clients receives a notification that their case has been audited or that it has been reactivated, The VA is committed to a 14-day timeline to audit the case once notification of potential reactivation, and then informing the claimant 14 days after that their case has been reactivated and what are the options for the claimant to take at that point. All right, John.
Hold on.
Thought I heard somebody's voice. Anybody have a question before we move on to the takeaway points? Hearing none, there are 4 points, the big picture points we wanted you to walk away with from today. Number one, the current status of the Veterans Court litigation, the Freund litigation. The Veterans Court has certified the class. So we're at a point where anybody who fits within the class definition, all of their entitlements that are at issue in terms of these timely perfected substantive appeals and the right to reactivation of them that now rises together or falls together. And we do have a proposed settlement agreement that would help them rise together if that settlement agreement were approved by the Veterans Court. All of the proposed settlement agreement has been agreed with the VA and filed to the Veterans Court. There are, of course, this is class litigation. The Veterans Court will review that proposed settlement agreement for fairness, reasonableness, and adequacy. It will hold a settlement fairness hearing to get the last bits of information that it'll consider on that. And then if it approves the proposed settlement, it's going to order VA to implement the settlement's terms. Will had mentioned mandate. We are asking that when the Veterans Court approves the settlement agreement, that it enter mandate and get the clock running on VA to audit these files and to provide relief, get these appeals back on track for decision. Takeaway point number 2, how are you going to identify potential Freund class members? Well, your task is going to be to identify each timely substantive appeal. You're going to try to rule it out from being a Freund class eligible appeal. If you can't rule it out, assume that it's in, write to VA, say, hey, I have what sure looks like is a timely filed substantive appeal that sure looks to me like it was erroneously closed. The more information you can provide there, you can provide the date of the statement of the case, the date of what you're identifying as the substantive appeal, the document category. Yeah, it shows up in VBMS as a VA form 21-4138 statement in support of claim, but here's, it sure looks to me like a substantive appeal. And then describing that I don't see a VA form 8, I don't see a board docketing notice, I don't see a board decision that marries up to any issue in the statement of the case. There is no prescribed form for doing this. I do not expect VA to create a prescribed form for doing this. So your favored method of communication, if you're somebody who likes to write, puts this in a letter, put it in a letter right in. If you prefer to put this in on a 21-4138, use that. But write into VA. Raise the prospect that there is an erroneously closed substantive appeal, and then that's going to trigger VA needing to audit the appeal file to see if it needs to reactivate it. I see a question, do you recommend sending the argument and audit request ASAP or wait until after the objections hearing for the Veterans Court is going to hold? As class counsel, my own preference is it tends towards orderliness, where if my life gets easier if folks wait. However, you have clients who are calling, and you have clients who are calling whose appeals may have already been warehoused for years. I think it would be eminently reasonable for you to make my life more difficult by just writing in as soon as you can. When you write into VA requesting that audit, if it is before there is any ruling as to the proposed settlement agreement, you are not at that point then under the proposed settlement agreement. What you're doing and what your first communication to VA should be is, in my view, the Office of Administrative Review. And if you want to put something in the claims file, great, do that too. There is an M21-1 provision that says that when VA identifies, on an individual basis, an erroneously closed substantive appeal, it's going to reactivate it. So that's ultimately what you're doing in terms of if you write in now. And so I am not going to tell you, don't write in now. It'll make my life, more difficult, but so what, right? Protect your clients. Third takeaway point we want you to leave with today is that the proposed class settlement agreement would require VA to review the closure of and to reactivate when warranted, not only each one of those 28,258 group of appeal files for which VBMS identifies a seemingly timely substantive appeal as such, but also each of the however many appeal files where the claimant does raise to VA within 1 year of mandate the prospect of an erroneous closure. And when I say however many of those appeal files, that includes and is not limited to, VA is going to send out individualized notice to each of the 64,599, at least up to, right? Unless VA can rule out saying this is just a blank 21-4138. Anything that is not is just a blank 21-4138. VA is going to send out these individualized notices saying, well, sure, it looks like a duck, sure, walks like a duck. If you tell us it's a duck, we're going to review this claims file and see whether it's erroneously closed. And if so, we're going to reactivate it. And so then beyond that 64,599 with the 214138 or the documents identified as 214138 and VBMS as potentially being substantive appeals, if there's any other third-party correspondence, other documents in VBMS that can look at it and say, hey, this is miscategorized in VBMS. This is a VA Form 9, or if not a VA Form 9, a substantive appeal that is timely, right into VA, and VA is going to have to review that appeal file. Fourth takeaway point is that this is important. You can provide significant help to your clients with this. Each of these erroneously closed appeals, they remain pending, right? This is continuous prosecution, to borrow from AMA language, going all the way back to the filing that led to the decision, notice of disagreement, statement of the case that then got closed. The erroneously closures go back as far as 1990. And so for each one of these veterans you're helping, you're talking about years, potentially many years of retroactive benefits which they might be entitled to all along, that then would of course make the life-changing difference for them and their families. And then finally, in terms of importance, VA, when they try
John,
to...
I was going to say, so we had two questions. So the first is from a Dawson Rouse. If this for non-Form 9 appeals, will the audit potentially result in the VA being allowed to construe at the ROI level whether a writing constitutes a substantive appeal? Will these decisions be appealable post-audit?
So what you will want to do in that case under the proposed settlement, the terms of proposed settlement agreement, the proposed agreement, the terms that we were able to get in there do not include a provision that VA must notify you if it is not reactivating the appeal. It's affirmatively deciding not to reactivate the appeal. So you're going to want to keep heads up in terms of clients for whom you have requested reactivation, and wherever you get that reactivation notice, okay, great, that's on track. If VA is silent, keep following up and request from them at that point an appealable decision as to the substantive appeals timeliness. And at that point, that request for an appealable decision as to the timeliness is going to then trigger VA to provide you with a decision from the AOJ level or RO level saying that this is not a timely substantive appeal, which yes, at that point you may appeal that.
Okay, so
I want to highlight that additional. Yep, go ahead.
No. Did that answer your question, Dawson? Okay. Second question then, if there's an issue on appeal or as part of a class action was reopened, will an AMA supplemental claim and is now service connected, will the VA reopen to see if there should have been an earlier effective date?
So will it is going to be different than should it. I'm going to answer from the perspective of should, because errors do happen, right? If there is a long closed, erroneously closed substantive appeal file that claim stream remains open, and then any additional filing that you put in later ends up being unnecessary as long as it's the same issue, right? You seek service connection in 2005, you go all the way up through a timely filed substantive appeal, you don't hear back from the board, and then in 2022, you file again, service connection for obstructive sleep apnea. That supplemental claim that you filed in 2022 never needed to have happened. And so where VA should go under the law is because that was an unnecessary claim filing. It should then adjudicate that long pending, what did I say, 2004 or whenever, initially filed claim for service connection for obstructive sleep apnea. And yes, grant the effective date going as far back as that initial claims filing date. It's going to be facts found basis, but still you're going to have that entitlement going all the way back to, in this case, 2004. To say that differently, if there are claimants who later, even while having an erroneously closed substantive appeal, made another filing, made a supplemental claim filing under the AMA, that is not going to have prejudiced their right to the initial claim, still open initial claim, the effective date they get to under that.
So a new question popped up. And this is for the group of the 28,000 plus. Will the VA determine and reactivate or on their own, or does the claimant have to request the reactivation? And will there be a deadline after audit notice?
For the 28,000 plus appeal files that are VA has identified that will be audited. And here, audit is a good thing. Usually your audit may cringe a little, but audit is a good thing. When VA determines that through their audit that the appeal file was closed erroneously, yes, VA must make a determination as to reactivation. And if reactivation is warranted, then VA must, with no further filing from the claimant, from the representative, from anybody, reactivate that appeal file. VA then will send notice of that reactivation to the claimant. If they can't find the original claimant, they'll look for the substantive claimant within their records and the representative to say, okay, here's what's next in terms of evidentiary window, because these are still legacy appeals, appeals. You can put in more evidence, supplemental statement of the case, or whatever happens next. So yes, the onus will be on VA for that group of 28,000 plus to make the next action. I'm going to scroll through questions, see if there are any others.
I don't think so, John. I interrupted you right before you were about to get to one of, I think, the meatiest.
The most important point. Yeah, no, thank you.
I know. This is the meatiest one. This is the one I think that makes the case this so important to our potential clients out there. So go ahead, John. I'm sorry to steal your
that's exactly right. While the Freund litigation was still being contested by VA, they did try to moot things out. They reviewed 5,456 claims they identified through a similar search pattern through which they ended up finding then later the additional 28,258. They were narrowly focused on the VA Form 9 specifically, and they were narrowly focused to only going back to like 2017. But even then, they found 5,400 of these apparently erroneously closed appeal files. They went through appeal file by appeal file for those. And when it did that, it found that 3,806 were in fact erroneously closed and VA reactivated them. And so among that grouping, these very similar search criteria that we have under the proposed settlement agreement, that works out to a reactivation rate or erroneous closure rate of 69.8%. So nearly 70% of these closed appeal files that VA found through this searching, it had to reactivate. And so among that 28,258 set, we are expecting 20,000 plus to be reactivated. And then among the 64,599, maybe that percentage goes down some, but we're still talking about thousands upon thousands of erroneously closed timely perfected substantive appeals that now VA is going to need to reactivate and bring along to conclusion. So please, this is very important for your clients. It will be a chore to go through the claims file and look at the statements of the case and then identify what looks to be a substantive appeal and follow up. But there really is high upside here for the clients. As you have questions going forward, please don't hesitate. And the questions today have been outstanding. Thank you. We'll do another request for questions before we sign off, but did want to extend an open invitation now. Please reach out to me. Please reach out to Will. And we will look forward to seeing any of you who are coming to the NOVA conference next week. We'll see you in San Diego, and we will hope to hear from you.